Case number 6, People v. Scott Barden. Mr. Greenberg, how are you, sir?
I'm good, thank you. Richard Greenberg, Office of the Appellate Defender, on behalf of Scott Barden. Good afternoon, Your Honors. May I reserve 2 minutes, Judge?
Okay.
Thank you. Your Honors, Scott Barden was denied a speedy trial, and the indictment should be dismissed for that reason alone. But in any event, the evidence was clearly insufficient to support a conviction for possession of stolen property and theft of services. Now, regardless of what you may think about Scott Barden or what he did or did not do to pay his hotel bill, he is simply not guilty of possessing stolen property in this case.
Could we deal with your first issue, the speedy trial
Sure.
issue, Mr. Greenberg?
Yes.
So if the people were never ready here.
Correct.
So, but the trial judge said that only 179 days would be attributed to the people because he left off that, I guess, the last adjournment that the people asked for, and the defense counsel wanted more time.
It's not quite that, Your Honor. There are 3 specific adjournments that we challenge here, one on January 5th, 2011, February 9th, and March 2nd. There were 3 consecutive adjournments.
Is any time in those 3, in the 2 previous adjournments attributed to the defendant?
Yes.
Okay.
Yes. In each of those 3 instances, the people said they were not ready, and they had never prior answered ready. So this is pre-readiness delay. They have never been ready in this case. On January 5th, they come in, they say, we're not ready, we're asking for January 26th. Defense counsel says, well, that's not a great date for me. Can we have February 8th or 9th?
So is it your position that those dates, that when defense counsel asks that those dates don't count to the people and not to you?
Correct. And that's based on this Court's decision in People v. Smith, which is a long-standing precedent. And in that case, this Court made it very clear that the rule is simply that when in pre-readiness delay, the people are responsible for all delays. Now, unless there's a clear consent by the defense.
What if the date that the people had asked for, you said, okay, we're ready on that day, and the court says, that day doesn't work for me?
I'm sorry?
What if the court had said, that date doesn't work, we have to do it?
Same thing. It's court congestion. This Court has held that if it's court congestion, whether it's based on the court's unavailability or defense counsel's unavailability. Now, I'm not suggesting if the people come in and say we're not ready.
Either way, it gets counted against the people, is what you're saying.
Yes. And
what does the actively participate language mean? What does
well,
it mean?
that's the problem here. In Smith, this Court used a phrase. Now, in Smith, this Court said the question is whether the people should be charged with time beyond the dates to which they requested adjournments. And since they never stated their readiness, this Court said, yes, they should be charged with all of that time. And the only exception now —
You got some case law that conflicts with that, though. People v. Worley.
Correct.
Conflicts directly with that.
Well, in Smith, this Court said the adjournments were precipitated by the people's failure to be ready. Other than stating that certain dates were not convenient, defense counsel did not formally consent and did not participate in setting a new date. So what we're left with is, what does that word participate? If you really want to create gamesmanship, you would say that a defense lawyer should say nothing. So when the people come in and say, we're not ready, we want 2 weeks, and the judge turns to defense counsel and says, is that date good for you? And she says, no, that's not good for me. And he says, what date is good for you, counsel? Defense counsel should say nothing and wait until the judge suggests another date, and then say if that's good or not good. Don't forget, the point of it is —
Well, what does happen if the defense counsel says, no, today is the day? Today is the day, and they're not ready. What should a judge do?
I'm not sure what I
Well, because this question about participating is the one we're trying to get to. So in your prior example and what happened here, defense counsel says the day that has been proposed by the people does not work for me.
Correct.
Here's an alternative date.
Correct.
So if defense
Did she
counsel comes in,
participate?
your response was, well, what if defense counsel just stands mute
Correct.
and doesn't respond? But what if defense counsel says no day other than today, or the day that they're saying they're not ready for, only that day we're available?
Well, that
That's
doesn't
it.
make any sense, obviously. Defense counsel has to be ready at some point. I think the question here
Well,
is
no,
what...
I'm saying you're ready at the time that you understood the
Right, and the
were going
people
to be
saying
ready.
they're not ready.
Right, but you say that this is the
I'm
day,
ready
it's another
today.
day.
The people
Correct.
say they're not ready. The people
You're not
want 2
giving
weeks.
consent, I
The
guess
people
is what
want 2 weeks, and on 2 weeks, I have to be in court in another county that day, so I can't be
I
here.
understand,
Judge.
then you're not consenting. So you're only saying, I'm available now,
Correct.
this is the day.
And then the judge says, well, when can you be here, counsel? And I say, well, I can be here 2 days later. Why should I be charged with those 2 days? It's all because the people weren't ready in the first instance. I think in the context of Smith, participate means that defense counsel is herself requesting additional time or consenting or in some way extending the adjournment beyond the time period that the people are asking for, not just setting a date that's
But
convenient.
isn't that what happened here today?
No.
In a case, for example, where the lawyer had another trial that they were involved in. And said, I need time to prepare for this other trial and so on and so forth. So this is...
She didn't say I need time to do anything other than I can't be here on that day because I have to be somewhere else that day.
Well, she said I had a date in the Second Circuit on the 8th, and I need to get that done.
Correct.
Right.
But
Okay.
the other one was, she had a trial and said, I have to get that trial done or I'll kill myself, so.
Right. And then the third one, she said the people request on March 2nd, they request March 16th. She says that's not a good day for me. Can we have the 28th? And the judge says, no, it has to be after April 8th. I'm going to give you April 13th. So there's 28 additional days there. And that's not defense counsel's fault. And keep in mind, the one thing that can prevent all of this is the people being ready. And they not only can answer ready on the record in court, but they can answer ready anytime they want by serving a certificate of readiness.
Yes, okay, but then they're not ready, so those days are going to be counted against them. And the question is, the date that you then got as the alternative date, or the new date, is one that defense counsel says, well, I'm not ready to move forward on that day myself. So why shouldn't that be counted
Because
against
defense
the
counsel
defendant?
never said, I'm not ready. She said, I'm unavailable that day. I need a different date because I can't be here that day. So she didn't say I wasn't ready. She was ready on all of these dates. The people were never ready. Not only were they not ready on these 3 dates, they weren't ready for another 6 months after this.
But ready
So
already contemplates availability, doesn't that?
No, I don't think so. I think that it's unfair to the defense if the people say we're not ready, and they keep coming in and saying we're not ready, we're not ready.
And those dates are counting against
And we
them.
want 2 weeks. You can't expect a
Yes, but
defense
those
attorney.
dates are then counting against them. I get your point, that every time they do that, they're really getting more than that. Because they must anticipate that defense counsel, or there's a likelihood that defense counsel won't be
But
available.
they can't expect that they have to get the exact date they're asking for, or else the
Well, I
defense should be
understand.
charged.
You're arguing that potentially they're gaming the system, that they're
Correct.
coming in and saying, I only want 2 weeks, when they potentially believe that the likelihood of 2 weeks is almost zero,
And-
and that it's really more time. But they now want to come in and say, give me 4 weeks.
Right. And you know what? If they were ready in 2 weeks, all they have to do is file a
Let's
certificate
do
of
this.
readiness.
Why don't we let Mr. Cohen address that, and we'll get you on to your substantive arguments. Your time is almost up, but we'll...
Okay, well, I think the speedy trial is substantive, and also the stolen property is
I didn't
substantive.
say it that way, yeah.
And the stolen property is substantive. Your Honors, this should be a clear case of statutory interpretation. On the one hand, first of all, as a matter of evidence here, there was no stolen property, nor was there any evidence whatsoever that Scott Barden possessed either constructively or physically possessed a credit card or a credit card number. He never even knew the number. But in terms of statutory interpretation,
But he was authorized for use of the number, right?
well, the hotel was
He had
authorized.
permission originally.
Right. The
That's
hotel
why he
had
had
permission.
access to the number.
Well, he never had the number.
But he has access to the use of that number, right? He has
Correct.
the appearance
Well-
of authority to tell the hotel, yes, charge it to that number. Correct?
Not quite, because what happened is it's the third party, Catalfamo, who interacts with the hotel, not Mr. Barden. The third party says to the hotel, here's my card number. I'm authorizing you, hotel, to charge his stay for X amount of money, and nothing beyond that. And then when Mr. Barden comes back, the hotel has kept this number on file and says, should we put it on the same card? And he said, sure. Is that a good thing? Not probably. But the question is, does he then possess stolen property by merely saying, yes, you can charge it to the same card?
Isn't the question whether or not a credit card number is tangible property?
That's one of the ways that you can rule on this, Your Honor, and clearly under...
Let me ask this question. Was that brought up below? Was that argued below? The issue, is a credit card number tangible property, or it can't be considered tangible property. Well, my understanding was it wasn't, and
Well,
so I'm wondering how we get to
during
this.
the charge conference and the motion to dismiss, and I would refer the court to page 437 of the appendix, defense counsel said, and perhaps a little inartfully, she said, "It seems to me by telling the jury that a credit card means a credit card number, I don't know what that means for commercial purposes, but I don't see how for personal purposes we can be talking about permanently depriving the owner of a credit card number." And so she is making the point that a credit card number is different from a credit card and that the statute really should only apply, the stolen property, possession of stolen property statute should only apply to a card and not a number. She doesn't make specific reference to the general business law. And that's the key here, because the penal law refers...
The card is meaningless without the number, right? The only thing that's meaningful in this particular example is the number, because they're not even asking for signatures.
Well, sure. If I have your credit card number, I can go and purchase things online. I can go to Amazon, whatever.
Correct.
And I'm committing a crime if I do that. What I'm not doing is I'm not possessing stolen property. I'm not possessing your stolen credit card number because your number is not stolen. It's an intangible item.
So the 511A, it's an amendment that was made to 511 of the GBL. Why doesn't that apply?
Well, 511-A is not an amendment to 511.
Okay,
It's
go
a
ahead.
separate additional statute that is entitled Additional Definition, and it says, for purposes of this article, only General Business Law Article 29, credit card also includes the number. That's all it said. And the legislature, if they really wanted to just amend the definition of credit card to include a number, all they had to do is amend 511.
But if Mr. Greenberg, if 511-A applies to the article, GBL, and the penal law says for the definition of property, you have
credit
to
card.
look to the other section that
511.
wasn't 511, that wasn't amended. But if isn't that sort of a backdoor way of making 511, amending 511 essentially?
Well, it would be a backdoor way, and when the legislature, if they had wanted to do it, would have taken the front door. All they had to do was go in and, why would they create a new separate statute specifically limiting this new statute to the general business law?
It says
And-
to this article of the general business.
Correct.
Which means that maybe they didn't want to go through each section of that article. They amended
It really
the
doesn't
whole
make sense,
article by making this one amendment.
Well, Your Honor, it doesn't make sense, and it's worth keeping in mind that the context of this is that this general business law additional statute, 511-A, was enacted at the exact same time that the legislature created a host of new criminal offenses in the penal law under Article 190 for identity theft and unlawful possession of personal identifying data. And those are in a different article. It's a completely different part of the penal law than the traditional stolen property and larceny offenses under 155, 160, 165, which is what we're talking about here. And that's why the word possession requires that you possess tangible property unless it's otherwise specified in the penal law. And for the personal identifying information crimes under Article 190, that is an exception to that requirement. In those sections, it makes it very clear that just knowledge of somebody's number or identifying data will be a crime in those circumstances.
So you're saying if I have the card, right, if I have the card, I can not only do the online, because I have the number because it's on the card, but I can go into the store.
Correct.
I can go into the store because I got something tangible.
Right.
But if all I have is the number, are you saying I can't go into the store too?
I'm not saying you can't go into a store. If you have somebody's number and you can make use of it, then you're committing a crime. There's no question about it. But the mere knowledge in your brain of someone's number is not in itself possession of stolen property.
I understand. The likelihood of doing that when you don't have the card and you have ID that may not match is what?
I'm
I mean,
sorry.
the number in particular seems to have most meaning for transactions where no one's necessarily looking at the card.
I suppose. But, again, we're talking about different statutes. And we're not saying that
Say this, if a credit card number isn't a credit card, then the entire holiday season where everyone in America calls on the phone and gives them their credit card number and essentially conducts a transaction every day in America that way, then you're saying that in point of fact that none of those transactions are actually valid because
No.
they have to be using a credit card.
Of course I'm not saying that, Your Honor. What I'm saying is that if somebody possesses somebody else, if somebody has knowledge of someone else's credit card number, just the number, but not the card,
The question before us is
Am
whether
I
or not...
guilty of
excuse me,
possession of
The question
stolen
before us
property?
is whether or not it's effectively the same thing as a credit card. That's the first question, which clearly it is, in point of fact, in the way the economy works. So the second question is whether or not the legislature has amended the law to reflect that and whether the penal code accurately reflects it, which is a different question you got a stronger argument on. But the fact that a credit card number is equivalent to a credit card, it's kind of hard to argue that it isn't.
of course, from a commercial point of view, of course it's the same thing, but
Well,
we're not talking about
actually,
that.
it isn't, because you need some other information.
Well,
Let's-
perhaps,
Let's
but
see if Mr. Cohn agrees with you, and we'll save
the
you.
last thing I will just say is that the second department, subsequent to this case, in matter of Louis C., which is cited in our reply brief, agrees exactly with the arguments we make and disagrees with the first department's ruling on this issue.
Thank you, Mr. Greenberg. Mr. Cohn?
Thank you, Judge Piggott. May it please the Court, David Cohn for the people. I'll start by responding to the 30-30 argument. And as Judge Fay pointed out, I think that this Court's decision in People v. Worley resolves this issue. Worley drew a distinction between situations where the people are responsible for the delay and the defendant is responsible for the delay. And in fact, CPL 3034B drew the same distinction. Said, yes, it's a people readiness statute, and people have the obligation to announce the readiness within the statutory time frame.
Let me ask you this. How is the defendant responsible for the delay between March 28th and April 13th?
Your Honor, under 3034B, the defendant consented to the final date is the short answer. And the long answer, under 3030...
How did the defendant consent? Did the defendant have a choice?
The defendant approved the date. The court's...
The defendant said, I'm ready on March 28th, or I'm available on March 28th. The court said, I'm sorry, we can't do it until April 13th.
Right.
How and when did the defense agree to the April 13th
Right.
date?
So, Your Honor, the statute says two things. It says that the court must exclude, right, periods of time that are either requested by the defense or consented to by the defense. The defense requested the March 28th date. When the court said that won't work for me, how about was it requested April 8th, excuse me. It was on the defense counsel said I'm on trial starting March 14, requested April 8th, if this is the adjournment you're talking about. And the court said April 13.
What should the defendant have done in that case?
Well, the defendant didn't have to request an adjournment at all. The defendant could have just stood silent while the people were asking for time. They could have come back to court at the later date. If the people weren't ready, then they would have announced not ready, and the case would have been adjourned. But when the defendant says...
But what if they were ready and the court said, okay, go ahead, and you know, the defense wasn't, you know, wasn't available, was on trial?
Right. And Your Honor...
Isn't that sort of game playing, too?
Your Honor, I'm not sure I understand what the game playing going on here by the prosecution is. The prosecutor, in fact...
Well, why couldn't the prosecution at any time along the way have stated their readiness?
Your Honor, the question...
They have to be in court to do that, did they?
They did not. On the other hand, the prosecutor is not under Sibley's, under People v. Sibley's, which this Court recently decided. The prosecutor should not and cannot announce their readiness until they're actually ready for trial. And, in fact, 3034A says this is not just you start counting the days until people are ready. 3034A and 4B, here 4B, anticipate a very different type of practice. It's really a give and take. If the people say we need time, that's charged against the people. Pre-readiness, if the people ask for time and the court says court congestion when you know they're weak, and defense counsel stays silent, that's charged to the people. On the other hand, the statute very clearly says if the defense requests or consents to an adjournment, then that is not charged to the people.
Every time defense counsel says the date that you're offering is not, I'm not available, I need the next day or 2 days later, you're saying the defense counsel is participating and therefore consents?
Yes, Your Honor.
So any defense counsel, if we decide that way, then any defense counsel will just roll the dice and say, I'll just be quiet, and and see if I can get my client off on 30/30 by just counting the days, right?
They could if they wanted to. I mean, what was really going on here is that there were two separate requests. The prosecutor made their request and stood silent, said absolutely nothing after that point. After that point, in each of these three calendar calls, the defense attorney then had a colloquy with the court where it was just the defense attorney and the court. The defense said, I want this particular date. The court said either yes, sure, or the court said, well, it has to be a few more days, and the defense attorney at that point says, yes, that's fine with me. That's consent to the delay. What the defendant would like in this case is an overly formalistic and unrealistic expectation of how the busiest courts in New York State have to operate. We have situations where there are judges with tons and tons of cases on their calendar. There are prosecutors carrying dozens.
What about the potential for gaming that your adversary refers to? That the likelihood of the ADA coming in and thinking that the day they're actually requesting is the day they're going to get. So in reality, they're looking for more time because they know the defense counsel will push it, and even the court may push it further.
Well, I don't think, Your Honor, that prosecutors are thinking that far in advance. They're thinking about they have calendars. They don't know what's going to happen on this case or that case. They know they need at least 2 weeks here. They know they need at least 3 weeks
Doesn't
there.
that beg the question that if the court, it's not a matter of when the trial begins, it's a question of when the people state their readiness. So if there's court congestion and the people only need 2 weeks, but the court can't accommodate them for another 4 weeks, all they have to do is submit their statement of readiness when they're actually ready.
Your Honor, absolutely. On the other hand, 3034B also states very clearly that if the defense requests an adjournment or consents to an adjournment, then that adjournment is charged to the defense and not to the people. This court...
These are knotty problems. I know that the people, at least in my experience, are always ready for trial at arraignment. And all of a sudden, and they're not. And yet, all that time gets, is not chargeable to them. It's really, as you're describing, I think, kind of an elastic thing that goes from court to court. But we'll take a look at it. Did you want to be heard with respect to Mr. Greenberg's?
Yes, Your Honor. I would like to talk about the stolen property issue as well. So first, to address another concern raised by Judge Fay, two of the main arguments the defendant is raising in this appeal with regard to the stolen property statute are not preserved for this court's review. First, the defendant did not argue at trial that a credit card does not include a credit card number. There was some argument at the charge conference about whether a person could permanently deprive someone of a credit card. But again, you don't need to permanently deprive someone to steal property. You could also appropriate. And more importantly, the defendant did not argue that the General Business Law Amendment 511A doesn't apply to the penal law. Never said those words. And secondly, the defense attorney at trial never argued that you cannot possess a credit card number within the meaning of Penal Law 10.08 Subdivision 8 because it's intangible. That argument was never raised at trial and is not preserved.
Didn't she say at one point, I'm just looking at my notes, that when the court was going to charge constructive possession, she said constructive possession of the card or the number because a hotel is the one that possessed the card number. There's no view of the evidence that Scott Barden's possession of the card number in the hotel is not, and the hotel is not his co-defendant. She said he never owned the car. He never had it.
Now, there is a preserved issue about whether the defendant actually possessed the card. And
wasn't that the whole point?
That's one of the four arguments they're raising. And we believe that the appellate division was correct, that there was sufficient evidence to prove the defendant possessed the card.
How do you distinguish theft of services and theft of stolen property in a context like this? If you use somebody's credit card number to steal something, I would think you're stealing services. If you're not stealing the card, because the owner of the card may have it securely in his wallet and he's comfortable. But in the meantime, services are being stolen in his name.
Yeah. Here, Your Honor, you're actually doing both. You are stealing services. If you walk into a restaurant and sit down and eat a meal and don't pay, you are stealing restaurant services. If you go to a hotel room and give them a card which is a phony, made-up credit card not belonging to anyone, and you end up not paying your bill, you're guilty of theft of services. Right. Mr. Barden here is certainly guilty of theft of services, and that's conceded by the defense. He's also guilty of possession of stolen property here because he not only did not pay a $50,000 hotel bill, but he appropriated the victim's account and used that first victim's account and used that victim's account to charge $10,000 in unpaid expenses.
Stole services.
That is true. He charged services, but he appropriated the account, and that's the theft. It wasn't just that he racked up a bill on his word saying, I'm going to pay, and didn't pay.
It's not either the credit card or the number, it's the account itself.
It's exercising dominion and control over the account.
What's the account? He stole this account. What is the account?
Well, it's the American Express account, which could be identified by the physical card or by the account number. That account number was provided to the hotel in the third party.
But you only know it's the account when you look at the number on the card. So you're still stuck with the number.
Right. And there's exactly, Your Honor, there's no, the number's
I mean,
important.
a card without a number is worthless.
Right.
Unless, I guess, you have one of those platinum or black cards, right? Maybe they
Right,
have
it's
no
like
numbers, I don't
some
know.
carte blanche. or
I wouldn't
something.
know. I hear stories about it, but I would not know.
That's a good point, though. Judge Rivera's point is, just thinking out loud, a card without a number is worthless. A number without a card, on the other hand, has value.
Right. And Your Honor,
I've got a number in my head right now, and I'm thinking Visa. Have I stolen somebody's card?
You do not know that number belongs to somebody else. You are not thinking of that number in your head with the intent to deprive someone or appropriate their credit account. Therefore, you have not committed the crime.
Did he know the number?
Sorry,
Did he
Your
himself
Honor?
know the number?
He did not know the number. He did not have to know the number.
That's why I get the theft of services. I just don't get the theft.
Your Honor, the theft is appropriating the account. He exercised dominion and control over the account for his own purposes.
Of a number he doesn't know and a card he doesn't have. He stole it.
Your Honor, the defendant made numerous assertions of his authority to charge to Mr. Catalfama's account, and these are in the facts of our brief. I'll just run them down very briefly.
Well, that's clearly a crime. I mean, we know that. That's defined in other sections of the penal law as a crime, specifically.
It's defined, you're talking about possession of personal information?
Yeah.
Yes. That is a misdemeanor if you possess somebody's personal information. Now, the difference between that crime and the crime of possession of stolen property is you don't have to know that the number is stolen in order to be guilty of unlawful possession of somebody's personal information. The stolen property statute, the reason it's a felony is because it's an offense related to theft. And the penal law defines stealing property, defines theft as unlawfully exercising dominion and control over somebody else's property with the intent to appropriate that property. And that's exactly what the defendant was trying to do here when on numerous occasions he told hotel staff and management that he had the authority to charge thousands and thousands of dollars of penthouse suites and room service to this man's account. He said —
I lost control of the clock, so could I ask you to sum up, and then we'll get Mr. Greenberg with his last.
Absolutely, Your Honor. In short, first, as we explained in our brief, the speedy trial adjournments, those last portions were chargeable to the people because they were not chargeable to the people because they were discussions solely between the court and counsel in which counsel requested and then agreed to the ultimate adjourned dates. And as to the stolen property counts, as the legislature has made clear in its 2002 amendments, a credit card number in this day and age is absolutely the same as a credit card itself. That was the entire intent of the 2002 amendments. And the defendant here knowingly exercised dominion and control over the account. He made numerous representations saying that that account was as good as his.
Even if he doesn't know the number?
Even if he doesn't know the number. Let's say the number could have been stored in the digital file. Here it was stored in the hotel's file.
He's never seen the number. He has no idea what this number is.
He doesn't know what the number is, but he knows that the number is on file at the hotel. He tells hotel management over and over again, I have the authority to charge my bills to this person's account number and do that for me. He was appropriating that account for his own use. That is exercising dominion and control over property that was converted to his use and therefore it was stolen.
Thank you, Mr. Cohen. We'll take a look at it. Mr. Greenberg.
Thank you.
I have to clear up some of the record problems. We're playing a little fast and loose with the record here. First of all, with respect to speedy trial, on the date that Judge Stein was asking about, on April 2nd, here's the record, what happened, and it's on page 63 of the record. The people are asked, are you ready? They say no. They asked for March 16th. Defense counsel says, I am going to be engaged in a civil trial on March 16th. I have to finish it or I will kill myself. The court says, what date do you want, counsel? She says, how about March 28th? The judge says it has to be after April 8th.
So you want to say the 16th to the 28th may be hers, but after the 28th, it's not.
I would not agree with that, but clearly anything after the 28th, when she said, how about the 28th, the judge says, no, it has to be after April 8th.
That's the courts. Right.
And the judge says April 13th, and her answer is, that should be fine. And according to my adversary, if she had said nothing when the judge said April 13th, that would be charged to the people. But because she answered the court and said that should be fine, she has now participated and, according to him, consented to that adjournment.
What if she said, well, I'd be available, but I don't consent?
That would be better.
What does that mean?
I don't know what that means. The point of it is, as Judge Stein had repeatedly said, all the people have to do, the gamesmanship here is that none of this time is charged to the defense because the people were never ready. This is a readiness statute.
The court is going to badger her until she says, yes, that's okay.
I can tell you, if the next time I give a CLE to defense lawyers in the city, which I do, I will tell them, do not participate, do not open your mouth. When the people request a date, just stand mute.
It depends
whatever
on
date they
what
pick.
we say.
Just show up in court on that day or don't show up in court because, I mean, it's a crazy way to do things.
Well, but if you say you're available but I don't consent, I'm not sure what that means. We haven't said, but that is
it's clear she wasn't consenting.
That is indicating a unwillingness to participate in the extra time, right?
She did not consent. She did not come in and say, yes, we're discussing a plea bargain, we consent to an adjournment, or I can't be ready that day, I'm going to be on vacation for the next 3 weeks.
She's just accommodating the court in your view.
Exactly.
The court says it has to be a certain
Exactly.
place.
And with respect to the stolen property, let me just make something clear here also. This is not a theft case. People are talking about a theft. They're talking about appropriation. None of that has anything to do with this case. This is possession of stolen property. So you need stolen property, which we don't have, and you need possession by Scott Barden of some stolen property. The property the people claim is stolen is a credit card number, not a credit card, a number which, as the court has noted, he never knew, he never possessed. The hotel had it. Not once did Scott Barden tell the hotel, as my adversary said, oh, I have the authority to charge $10,000. He never said anything like that. He came there and they said, should we put it on the same Amex card? And he said, sure, go ahead.
I should talk to my accountant.
I'm not saying he's not guilty of some crime here, and it may be theft of services. The problem in this case is that theft of service is a misdemeanor. If you jump into the subway without paying your Metro card fee, that's a theft of service. If you stay in a hotel for 6 weeks and rack up a $50,000 bill and walk out without paying, that's a theft of service.
Would it be different if if Mr. Catalfamo wasn't able to reverse the charges and he was out that money rather than the hotel?
Well, then you might have some other situation. You might have a claim of larceny of some kind. But he wasn't out of the money. Nobody was out of the money. In fact, Mr. Barden never left the hotel. He was still scrounging trying to pay this bill when they came and arrested him. It's not like he walked out without paying his bill. He was there. He thought it was being covered by one credit card. He tried to get a different credit card to cover it. Again, I'm not condoning his conduct here, but the question is he guilty of criminal possession of stolen property under these circumstances? And if the court says yes, then we're opening up a big can of worms as to what could be in someone's mind, possessing a number that you never even knew in your life, that somebody else, if he walked into the hotel and said, listen, my friend Catalfamo is going to pay for this, charge it to him, is that possession of stolen property? I don't think so.
We'll look at
and that's not really any different from what happened here.
Thank you, sir.
Thank you very much.
Thank you both very much.